Um, well, honestly, I was able to.
Okay.
I'm sorry.
Today.
Well, maybe like probably a couple hours, 3 hours.
Sir, that's not happening.
Well, I mean that would only. See, this is what took place last time when I spoke to the fact that you're showing impropriety, which is a violation of judicial procedure. And all I'm trying to do, I'm not here the flesh and blood man and trying is being put on the same standing as an artificial person, which I am not. I'm a flesh and blood man. Come from.
My name is Uraine Washington, and I'm the judge that will be presiding over this session. The court will call the case of Country Meadows Apartments versus Tariq Day and Erica Witherspoon. Case number 23C0276.
Good afternoon, Your Honor. Christopher Borkin appearing on behalf of the plaintiff.
Good afternoon.
Hello.
Hello, we can hear you, Mr. Day. Please state your name. Can you please state your name, sir?
You hear me?
Yes, please state your name.
Hello.
Can you hear me, Mr. Day?
I was going to respectfully request it. Was there?
Can we please
escrow?
let him say his name first?
Yes, absolutely.
Mr. Day,
Yes.
could you state your name, please, sir?
I am Teresa Martari.
Thank you, sir. All right.
Your Honor, was there escrow ordered in this case?
No, there's no escrow that's been ordered.
Understood. I think there was some confusion on my part early on. Plaintiff respectfully requests the court to find no triable issue today. Rent to retain is $4,323.60.
Mr. Borkin,
Yes, Your Honor.
I'm going to need you to address the issues that we left off with before we get to that, which
Absolutely.
was the fact that at the last time we were here, there was a Ypsilanti Township property code violation notice that was posted, and we didn't know the details of that or the status of that.
Yes, Your Honor. I did investigate that further between last hearing and today. There were two items that the city requested fixing in Mr. Day's apartment. One was a gash in the kitchen floor. They requested that be fixed or replaced because it was a tripping hazard. And the second item was a gap between the window and the windowsill or somewhere in the window or window frame. They requested those two items to be addressed. They have been addressed, Your Honor. The floor was replaced on the 4th of April, and the gap in the windows was fixed today. The reinspection was today, Your Honor, and the city inspector did indicate that the problems were addressed, that there were no further actions to be taken by my client.
Thank you. Mr. Day, is that true?
Are we addressing the my claim for the
Mr. Day, could you please answer the question about whether that is true or not?
the floors were fixed, but the windows were not. But aside from that, I was needed to know because we didn't ever address the issue of the violation of my consumer rights.
Your Honor, the city did indicate that the windows were fixed satisfactory to a satisfactory point where they requested no further action be taken.
Okay.
May I speak or whenever you're allow? I can wait.
Thank you, sir. Mr. Morgan, you may proceed.
I'm sorry, Your Honor. I was closing my door. Could Mr. Day repeat the last thing he said?
Mr. Day,
I can
he
wait.
said he could wait later to talk, is what he said. He wants this opportunity to speak. That's all he was saying.
Understood. Thank you, Your Honor. May I proceed with the facts of the rental arrearage?
You may.
Rent to retain is $4,323.60. Court costs are $158, totaling $4,881.60. Plaintiff respectfully requests the court to find no triable issue today.
Thank you. Mr. Day, your turn.
I would like to address the violation of my consumer rights. I wasn't given full disclosure. The primary violations are, sorry, I wrote them down. I'm sorry. There they are. The primary one was the right to consumer education, as well as the right to be informed, which also alludes to my right to choose. I wasn't given full disclosure upon all the information of the contract. I was not told about my right to the education of the consumer transaction that was going to be taking place. I wasn't told that as of the consumer credit transaction that took place, the consumer purchase that took place, that I was in fact the creditor of that account, because with our private property being the signature, it was given the contract, it gave the contract interest, and we became investors within the trust agreement of between Country Meadows Apartments LLC and the natural persons, consumers on the contract. And I would like the opportunity to be able to effectively perform our defense in regards to the claim that was sent to you all as well. Yes. So with that all being said, I would just ask for a date to be able to provide my defense and all my evidences.
Today is the date for any defenses and evidences. Mr. Day?
I was not told that. All you said about this meeting was that we'll be speaking on the corrections of the township document or inspection. I was told that this was going to be a date for me to be able to provide my defense. Yeah, that was never talked about. And when I did try to speak, I was kind of bombarded, and I was under a sense of duress. And I'm just asking for a proper date for me to be able to provide my defense, as is I am allowed through the Consumer Bill of Rights, which I have the right to be heard efficiently and without any kind of forced action because of a lack of communication and transparency. I was not told. I don't know if I know it's not on the record because I went back and I watched the recording on YouTube. It was not stated that this is going to be a day for me to provide my defense. So if that is what's being said, then again, that'd be a violation of my Fourth Amendment right, as far as the United States Constitution goes, and as well as what I already mentioned, my consumer right of having the right to be heard.
All right. Anything else you want to present today, sir? Because today is the hearing.
That's the whole point. I was not given I wasn't told that this was going to be a date, so wasn't allowed the proper time to have all my evidences present so I could put them on the record.
All right, thank you, sir. Anything else, Mr. Morgan?
Your Honor, from what I gather from Mr. Day's statements, there are certain things that seem to refer to the motion that this court already ruled on. I will not address those. There do seem to be things along the lines of what Mr. Day was told in terms of his rights as a person signing a lease in Michigan. I will indicate for the record that my client's lease has all the proper disclosures under Michigan law to Mr. Day. Mr. Day did, in fact, sign his name to that lease agreement. And I would again ask the court to find no merit to those arguments and no triable issue. There is this other issue that I can gather with there being a trust agreement and Mr. Day being an investor of the property under that trust agreement. Your Honor, I've seen no evidence to support this claim. And if there is any merit to this claim, it has nothing to do with the possession judgment plaintiff is requesting today. Thank you.
Thank you. Today is a date and time that was scheduled for the continuation or adjourned trial date from last time due to the fact that there was a township violation that needed to be addressed. This court having heard no defense to the actual amounts that are being claimed at this time. Today, why are you interrupting me, sir?
You're stating that the court doesn't have any defenses or haven't heard any defenses from me, and I have the trust agreement, the equitable ownership of the property, as well as equitable ownership of this account, and I can provide the certificate of trust, which states that the property is within the trust and has been conveyed to the trust, and also that in regards to the alleged amount owed, I can provide the fact that is a violation of, 15 USC 1692C, which states, yes. If a consumer notifies a debt collector, the debt collector would be Country Meadows Apartments LLC, that refused to pay the debt, or that the consumer wishes the debt collector to cease further communication with the consumer. The debt collector shall not communicate further with the consumer with respect to such debt, except to advise the consumer or the natural person that the debt collector's further efforts are being terminated. 2, to notify the consumer that the debt collector or creditor may invoke specified remedies, which are ordinarily invoked by such debt collector or creditor. And I am notifying the debt collector or Country Meadows Apartments that I am the creditor, and I am seeking invoking, my specified remedies to settle the matter at hand. Again, according to the alleged amount owed, I do not agree with that. And I can also provide the violations tied to that.
Violations, sir.
The first would be, I'm sorry, I'm trying to get it all together. As I stated, I wasn't given notice to have this all concise. You'll give me a brief moment. Well, one of them would be 15 USC, subsection 1692, E, which states a false character, amount, or legal status of any debt, also known as if the amount shown is positive, it is false and misrepresentation. If the balance was owed in a bank account, it would be shown in the negative. This amount is shown positively, which makes that the person makes it so how can a person pay on a positive amount unless there's a double or the T ledger bookkeeping being presented, which again goes to my violation of my consumer rights of not having full disclosure. I wasn't told that there will be a T ledger accounting being performed, to whereas the positive balance that's shown that I received from the assistant Stephanie Robust, I believe this was last month, so it didn't have the alleged incurred or additional amount that brings it to the alleged 4,800 or whatever. The price in that she gave me was as of March 6, 2023 was $3,700. And as stated in 15 stated in 15 USC 1692, if the balance were to be viewed in a bank account, it would be negative. So if I were to receive a correspondence from or a bill from Country Meadows Apartments, it would have that the alleged balance owed would be a positive balance and not a negative balance, which again is a misrepresentation of material information. So as I stated, I would just truly appreciate an opportunity to get all my defense together properly. You stated this was going to be a continuation to the matters of the township violations. And again, I was not given proper insight or I'm sorry, the term leaves my mind, but I wasn't given proper notice to have my defense prepared. Also, to the point of Mr. Borkin saying, excuse me, that the contract or the lease is up to Michigan standards. There were a few violations of the Truth in Lending Act and the Landlord Tenant Act of Michigan within that lease. One being, I'm trying to remember off the top of my head because I don't have it in front of me. But one in particular was a waiver of trial by jury, or which is a not a priority, but it is I guess a precedent, for lack of a better term, of a right that cannot be waived, or cannot even be put into a lease agreement because it's a violation of the landlord tenant relationship act of Michigan. Also to the point of, it talks about oh yes, to the point of the accounting, the misleading representation of the accounting matter on behalf of Country Meadows Apartments LLC, to have everything be verified to the fact that the amount owed, the alleged amount owed, is covered via the obligation of the United States, which I believe is 18 USC 8, that states that all obligations are handled, for lack of a better term, by the United States, since I am the first in line creditor, since the United States is bankrupt and insolvent. All credit is issued via consumers, and as I stated earlier, without my without the uncontracted use of my private property, which would be my signature, which Country Meadows then used to, excuse me, to invest within itself without giving the ability to accept the interests that were incurred from the investment, of the initial investment, and to have a solid view of what I'm speaking on. I will request a securitization audit to prove that the instrument or the promissory note was not securitized, which, if proven, it would show that securitization is a voluntary act of destruction, and which would mean that the contract was discharged. Yes. So again, requesting, along with the securitization audit of the account, requesting proper time to be able to further prepare my defense, so that I can have all my rights, so that I may be able to enforce all my rights, since, as I've stated, they have been violated numerous times in regards to this matter.
All right, are you done, sir?
Not really. if I'm allowed to gather my information, then yeah, I'm definitely not done. If that's something I can do now, then I can get all my evidences uh together, and then be able to present uh my defense, which currently uh I'm being forced to do ineffectively, or not ineffectively, but not as efficiently as possible, because of the lack of transparency and communication on behalf of the adjudication or the procedural process of this accounting case.
How long do you need to gather whatever it is you're gathering, sir?
Um, well, honestly, I was able to.
Okay.
I'm sorry.
Today.
Well, maybe like probably a couple hours, 3 hours.
Sir, that's not happening.
Well, I mean, that would only see. This is what took place last time when I spoke to the fact that you're showing impropriety, which is a violation of judicial procedure. And all I'm trying to do, I'm not here to be a a enemy of the state. I'm a friend of the court, and I'm simply here to settle the matters that have been brought to the public, which it should have been handled privately from the get-go, which I attempted to initiate, which was uh, um, wrongly dismissed. So I'm simply just seeking to be able to enforce and act out my rights, which are protected through your oath of office to the state of Michigan, as well as to the federal constitution, or the state of Michigan constitution, as well as the federal constitution. And I am seeking to enforce my rights that are protected through both the United Nations Declaration of the Rights of Indigenous Peoples and the American Declaration on the Rights of Indigenous Peoples, which states that all state agencies, I'll pull up these specific statute from the American Declaration on the Rights of Indigenous Peoples. If I'm not mistaken, it's Article, one of them is Article 21, which is the right to autonomy or self-government. Indigenous peoples, which I am, in exercising their right to self-determination, have the right to self-autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means for financing their autonomous functions. Indigenous peoples have the right to maintain and develop their own decision-making institutions. They also have the right to participate in the decision-making matters which would affect their rights. They may do so directly or through their representatives and in accordance with their own norms, procedures, and traditions. They also have the right to equal opportunities in accessing and participating fully and effectively as peoples in all national institutions and forums, including deliberative bodies. The other, well, there's quite a few, but another one of the violations that has taken place is of section 2 of the same document, the Declaration, American Declaration of Rights of Indigenous Peoples, section 2, article 5, full effect and observance of human rights. Indigenous peoples and individuals have the right to the full enjoyment of all human rights and fundamental freedoms as recognized in the Charter of the United Nations, the Charter of the Organization of American States, and international human rights law. Article 6, indigenous peoples have collective rights that are indispensable for their existence, well-being, and integral development as peoples. In that regard, states recognize and respect the right of indigenous peoples to their collective action, to their juridical, social, political, and economic systems or institutions, to their own cultures, to profess and practice their spiritual beliefs, to use their own tongues and languages, and to their lands, territories, and resources. States, which you are a contractor of the state of Michigan, states shall promote with the full and effective participation of indigenous peoples the harmonious coexistence of the rights and systems of different population groups and cultures, which further validates my statement that throughout these proceedings, I've stated how my international rights are being violated, my human rights are being violated, my consumer rights are being violated, the rights that are protected through the constitutions in which you took an oath to uphold are being violated, and your actions, not to say that you intend to have done this, but your actions have been violations of those rights. And as I stated, I'm not here to, be an enemy. I'm just simply here to have a true and rightly presented defense, so that it can be shown that so that I can show the facts that are taking place. Also, to the point of which got me to a point of duress and stress, was not last time, but the time prior. You stated that had I not raised my hand or whatever the case to be placed under oath, that my presentment wouldn't be. I don't want to quote you because I'm just off the top of my head. I know it was something to the effects of it wouldn't be on the record or it wouldn't be taken under oath, which I stated would be your actions, though maybe not intended, were regardlessly implied that had I or if I did not raise my right hand or whatever the case, my statement wouldn't be under oath on the record. And I stated that that action that you're taking will be forced assimilation, which again, this is the American Declaration of the Rights of Indigenous Peoples. Article 10 states the rejection of assimilation. Indigenous peoples have the right to maintain, express, and freely develop their cultural identity in all respects, free from any external attempt at assimilation. Again, states shall not carry out, adopt, support, or favor any policy of assimilation of indigenous peoples or of destruction of their cultures, which would, if done, if those acts are committed, would be an attempt at genocide of our culture. And again, there's a multitude of human rights violations, international rights violations that are taking place. And I am not being afforded the proper time to perfect and present my defense, along with my affidavit, which has yet to be rebutted, has been was wrongly stated to be a motion, which an affidavit is quite different from a motion. And as an indigenous person, when dealing with juridical or adjudication processes, I self-determined to move through affidavit, which a maxim of law is that an unrebutted affidavit stands as fact. And my affidavit that I tried to or attempted to handle these matters privately, since again, as I stated earlier, this is a private matter that is being brought to the public, which is even more so uh, an action of defamation of character, because now I'm in the public realm being recorded on YouTube, can be viewed by anyone, and it's showing or attempting to show that I am irresponsible of handling my own affairs as a man, and a man of the age of majority. And also to the fact of the alleged or assumed name, the misnomer, which is being presented, is a business entity which was created through or by way of the birth certificate account, which is a trust, because the birth certificate is an investment, or a what is the word? Woodrow Wilson stated it is a registration of our biological properties, which any contract that stands, which whose initial or foundational documents are not factual, or were not given excuse me, if the foundational documents of a contract were void, it voids the entire any and all contracts that come from that initial contract. And with that being stated, you all, the court and the plaintiff, are trying to or attempting to use a fictitious entity, a misnomer, to identify me as the flesh and blood man. I am a child of God, a child of Allah, first and foremost, before anything. And as it says in Philippians, I'm a citizen of heaven, first and foremost. And I am a part of the original trust relationship, which stems from God, Allah, being the grantor of all things, and who gave man the granted man the position of trustee and beneficiary over the earth, as stated in Genesis 2:20. God granted man the dominion over all things of the land, water, and air. And I am a man who has dominion of all those things. And what is taking place is a situation where I, the flesh and blood man, am trying is being put on the same standing as an artificial person, which I am not. I'm a flesh and blood man, come from the womb of a mother, and the all caps name that is being used to proceed within this case is actually artificial entity. And I don't agree to the idiosynonyms of trying to establish that the name that you require to be put on the record is a form of identity. No one can prove or successfully prove that the identity of the part of the alleged defendants of this case. All that to say, as going back to all the violations that have taken place, I'm simply requesting enforcing my right to have proper time to defend or to present my perfected defense, which I am currently not being allowed.
Your Honor, Mr. Day has had 3 weeks just since the last hearing. This is the sixth hearing.
I'll let you speak.
First time that we're hearing them. None of them have been submitted in writing to plaintiff.
I didn't cut you off. Last week you stated.
Sir, but in all due respect, he spoke for about 3 minutes. You've been speaking for 30 minutes.
And I would have been able to be more concise had I been told and had full transparency and communication of the stature of the proceedings or how they were going to move on. I was only told that we were going to address the township violations. Nothing else was said to the matter. And for you to sit there and try to force me in a limited time frame to just off the top of my head come up with or provide all of my defenses to you is, again, as I stated, has been all through this proceedings, is a form of impropriety, which...
All right, can you mute him, please?
Yes.
And
Sir, you've been speaking for 30 minutes, repeating the same things many times. At this point in time, we've come here. This is the sixth time we've been here. It was 3 weeks between the first hearing, the last hearing, and this hearing. We've been here 6 times. You've had plenty of opportunity to provide a defense. At this point in time, I'm agreeing with the plaintiff's counsel that there is no tribal issue of fact. I deny all of your myriad of arguments as lacking merit and baseless, for that matter. And at this point in time, I'm issuing a judgment in the amount of $4,881.60. You have 10 days in which to pay that amount, or they will be coming to seek a writ of eviction. This case is done.